And at this time, I'm going to pass it over to Liz Vos from the Office of Mental Health, who will kick us off.
Okay. Thank you. Hi, my name is Liz Vos. I'm with the Division of Managed Care at the Office of Mental Health. I want to thank you all for taking the time to call into this webinar. It's been about close to 2.5 years since we transitioned the entire behavioral health system for individuals 21 over into managed care, and a little less so in New York City and a little less so for areas outside of New York City. And we thought it would be appropriate to kind of offer providers a refresher on the protections that we built into the model contract. This is a document that has now received approval from CMS, so it is visible to folks, which we'll show you where you can find it in just a moment. So, Tricia, if you go to the next slide. So the Medicaid Managed Care Model Contract is a legally binding document, a contract between New York State and Medicaid Managed Care organizations, and it identifies specific requirements that govern the way managed care organizations do business. And when we did the behavioral health managed care transition, we worked very closely with our partner agencies to develop specific legal requirements that pertain to management of the behavioral health population and benefits. And we wanted to really walk you through, we're going to walk you through some of those provisions later, but the legal requirements that what we were trying to get at was to make sure that we were creating a system that would allow the money to ultimately flow through to providers by way of the managed care plans through, the submission and payment of claims. Which is something that we monitor continuously even to this day on a monthly basis. We also required the managed care plans to contract with a minimum number of providers. So we wanted to make sure that the providers that were doing business in the old world were still able to do business with managed care plans. So we gave them specific requirements pertaining to that. And we also built in authorization requirements to make sure that folks were not being denied care. But we'll walk you through some of those areas. If you go to the next slide. We wanted to provide you with the link of where you can go to find this model contract. And it's a holistic contract. It includes every single requirement pertaining to Medicaid managed care organizations. And so the behavioral health provisions are sprinkled throughout. Were you able to pull it up, Tricia? So if you just to kind of show you specifically what it looks like, this is the Medicaid managed care model contract. It shows you that it was amended October 1st, 2015, and that was in line with our the behavioral health transition. It's several hundred pages, and you'll see there's a table of contents. It'll give you definitions that you can look through, but even if you do a Control F and find anything related to behavioral health, you can garner every single requirement that we built in. So it's very helpful for providers. We recommend that you take a moment to kind of go through that so you can understand what requirements are being put on the plans. So I'm going to pass it over to Ileana Meltzer to go through the first part of the contractual protections.
Hi, everyone. Good afternoon. This is Ileana Meltzer from WASAS, Practice Innovation and Care Management Division. And just to push back a little bit on the conversation that we were having about taking a look at that model contract, just to remind everybody of a few things. Both agencies had already released a document that does a more section-specific line out of the provisions that are specific to and of interest to the behavioral health community. Those documents were released within the last 2 years. From the OASAS perspective, it's available on our managed care provider pages, and what it does is it tables out a lot of the provisions that are specific to the behavioral health integration. Both agencies are in the process of updating and releasing those documents. The updates are primarily clerical in nature, as there were some section changes just numerically from the documents that were previously released. So Liz is absolutely right. The Medicaid Managed Care Model Contract is comprehensive. When we did the initial rollout and did training for providers a couple years ago, we did suggest to people that you become familiar with the model contract generally, not just the behavioral health provisions, because what providers will find is as they're communicating with plans, communication hits on a variety of topics, including but not limited to those things that are specific to the behavioral health protections. So it's helpful if you have people in your organization that are relatively fluent in both the construction of the document, where things are primarily located, and have an understanding about how the pieces connect together in relationship to reimbursement, access to services, and network construction. So for today's presentation, what we wanted to do was just highlight 3 of the areas that were of particular interest to the field as we transition the services into the Medicaid Managed Care Benefit Package. Generally, those things speak to payment protections, network construction, and access to services. Next slide, please. So one of the major pieces that was put in place when the services were brought into the benefit package was the concept of government mandated rates. So in the main, services that were brought into the benefit package, primarily outpatient services, to the extent that they were covered by the APG services and those services were run through the grouper, those prices would be dictated. But there were also services that were outside of the grouper for which the government mandate also applied. There was also an extension of that government mandate through 2020. We believe everybody at this juncture is aware of that extension, but it was worth re-signaling it today. So again, the government mandates are in place through 2020 for those services that government rates apply. Those include services that are run to the APG grouper, but they also include services outside of the grouper, for example, like home and community-based services. These last 2 pieces just talk about there have been instances where a claim has been submitted that may not necessarily be in accord with what the government rate is. This is just a reminder that that government rate still prevails. And one thing that Liz signaled in the beginning of today's presentation and continues to be true and will remain to be true is the state is actively and continuously engaged in working with plans when there are claim submission and reimbursement issues, either something that is unique to a specific provider or systemic generally, and you can use either one of either the OMH mailbox or the OASAS PICA mailbox to continue to bring those questions to our attention, as well as there are other venues where providers get together with plans where those issues can be brought to our attention. Next slide, please. So again, this is just a reminder that within the Medicaid managed care arena, providers are required to submit claims within a certain time frame as articulated in the slide here, and plans do have their prompt payment requirements. In some instances where providers have had a technical issue with getting the claims through, they've been able to have a communication with the plan about signaling that there might be a complication with meeting that timely submission, particularly during the initial implementation. We do still from time to time have those conversations. And also the prompt pay claims. Those are not specific to the behavioral health services. They are operational through the plan generally, but we just wanted to remind people about those provisions. Next slide, please. So providers will also recall that another main objective of the transition of behavioral health services into the Medicaid managed care package was constructing a network that was not only robust as far as access to the different services, but also allowed for a smoother transition to bring in providers into the networks to allow continuum of care to services, not break people up from a provider upon transition. So one of the things that was put in place when we first started was this third bullet down, talking about when we first pulled the benefit into the Medicaid managed care benefit package, plans were offering contracts to providers that had 5 or more of their members. The date for that is timed to when the benefit was pulled into the benefit package. So that would be October 1 of 2015 in New York City and July 1, 2016 of rest of state. Beyond that, once that 5 or more provision is no longer in place, there are robust network requirements that are program type specific, both on the OMH side and on the OASAS side. Those network requirements are primarily housed in Section 2119 of the Medicaid Managed Care Model Contract. And the way it's laid out is it goes by the licensed or certified program type, and there is some variability on the network requirements. An example of that is in the OASAS system, the opioid treatment programs are deemed essential community providers, so the plans have a requirement to contract with that, with all the OTPs that are in their particular county or area, and you'll see the specifics of that in the contract. So again, that's why I'm encouraging everybody to take a look at the contract and the different pieces, because there is variability on the network requirements based on what your licensure or certification is. Another piece that was put into place is the plans when they're contracting with the OMH licensed or the OASAS certified program, they contract at the program level and they don't do individual line level practitioner credentialing. And so finally, what I just want to have people think about as they leave this conversation is going back to that contract, understanding what the ongoing network requirements are. So as we transition away from that 5 or more rule, people are fluent on what are the obligations for having that complete network. And with that, we are going to transition to Tricia Allen from OASAS.
Okay. Hi, everyone. My name is Tricia Allen. I'm with Counsel's Office at OASAS. If any of you have ever talked to me, you know that they call me T. So a couple of things that I just want to bring up, a couple of protections that were included. This first protection is called the All Products Clause. This is an extremely important protection. Essentially what it says is the plan absolutely cannot in any way, shape, or form require the provider to participate in the plan's non-Medicaid lines of business. This is an absolute. There is no wiggle room on this one. This is a definite one. If you see this in your contract with the MCOs, scratch it out, call us, let us know. This one is a very, very crucial component for us. In addition to that, we also have what are known as service access protections. So this essentially just lays out the circumstances when there won't be prior authorization. Obviously, for the behavioral health side of the world, access when somebody's ready is crucial. So one of the requirements within the contract is that there will be no prior authorization for OASAS Part 822. And when I say 822, that would be outpatient rehab, and then we also have opioid treatment programs, which are within our 822 regulations. That would also apply to the 816 medically supervised outpatient withdrawal and stabilization services, and then on the OMH side, it's the Part 599 licensed outpatient clinics. So that is a prohibition against the plan requiring you guys to call them and get authorization for the individual to go to that program, and that's for urgent or non-urgent ambulatory services. So just be aware that that's there. I will also add that there are protections in place for the behavioral health pharmacy services. So it's immediate access and no prior authorization for prescribed medications, and that's for 72 hours. And then specific to opioid management / withdrawal and stabilization, there is a provision within the contract that allows for a 7-day supply. So do be aware that if you run into an edit in the system for some reason when someone's trying to access that medication, that there is something going on there that shouldn't be happening. I will also note that there is a statutory change which took effect after the contract was amended, and I would anticipate will be referenced at least in the next cycle of contract amendments, which has to do with the medication for opioid withdrawal and/or stabilization. Now that is for an emergency access to a 5-day supply. So obviously our contract goes above and beyond that, but I did just want you to be aware that that's out there. Also, please note that there is guidance available for you. We provided you with the link, and that is speaking specifically to prior authorization. Oh, okay. So some other service access protections that you should be aware of. We did write into the contract that individuals have unlimited self-referrals for mental health and substance use disorder as long as it's with a participating provider. So be aware, no, there can't be any prior authorization or referral or a requirement for referral from a primary care practitioner. Another item that is within the contract, and I will also note, is within statute requires the use of, in this case, it's locator, the OASIS level of care for alcohol and drug treatment referral. This is a web-based tool. As an OASIS provider, I'm assuming we're all intimately familiar with it. And that has to be used in order to determine the level of care for anyone being admitted into an OASIS treatment program. We included the link for you if you're not familiar with it. But there is also statutory changes that were enacted in 2014 and in 2016, which speaks to the use of an OASIS designated tool when you're making decisions about substance use disorder treatment. In addition to that, we had some changes that became effective January 1, 2017, which have to do with vetted treatment services. This is also not in the current contract, but we would anticipate will be included in the next contract cycle. And that just provides that an individual who is seeking, there won't be any prior authorization for a person who's seeking vetted treatment at an in-state, in-network OASIS provider. So the plan can't require you to do any type of prior authorization for those patients. And there is also a prohibition against concurrent review for the first 14 days. There are some caveats to that provision, specifically that the provider has to give notification to the plan within 48 hours of the patient's admission, and they also have to provide them with the initial treatment plan. OASIS did issue guidance, and I will ensure that they provide you with the link, which I'm realizing I didn't include here. But we did issue guidance around this law and created a form. We call it the Attachment A, which I know is a very catchy name. Which you can use to submit to the insurance company, and it just gives, it's a one-page document. It gives a very brief bit of information about the patient and what your initial plans are for that patient. There is the expectation that the provider is going to regularly assess the individual to determine if they still need to be in that level of care. I will say, over and over again, that this is not the 14-day rule. This is not an automatic 14 days. This is a, if you need 14 days, you can get it. If you need 20 days, you can get it. If you need 3 days, you can get it. Obviously, if you're a detox program, I'm not sure that somebody would typically be staying for 28 days or 14 days. So it's supposed to be based on the individual's needs. There is also a requirement that there be a periodic consultation with the plan. So you do need to speak with the plan. I've heard some plans do once, a quick check-in, leave us a voicemail. I've heard other plans who maybe do a little bit more detail. They want to know, you know, what the discharge plan is, and it's really an opportunity for the providers and the plans to work together, talk to each other about, you know, how the patient's doing in treatment and what the plan is going forward. But it is absolutely not expected to be a situation where you call up the plan and the plan advises you that you need to get that person out of there. They're only going to pay 1 or 2 more days or anything like that. I will note that in the law there is retrospective review permitted. And then, again, obviously, as I said, this is not currently in the contract, but we would anticipate that this would be in the contract in the next cycle. Okay, so with that, I'm going to turn it back over to Liz.
So just, we laid out some things that we wanted providers to walk away really just knowing what to do. And one of the key things was to really look at the provider agreements and to make sure you understand what's in there. And strike anything, obviously, that looks uncomfortable or detrimental. So one of the things we recommend is we provided some recommended language that might help offer some support that identifies if there's anything in the provider agreement that conflicts with anything that's within the model contract or guidelines, that whatever's in the model contract or guidelines will prevail. And so that adds that level of security. But there are DOH standard clauses that are required already to be in provider agreements, and those are general enough to support the behavioral health requirements that we've laid out. But we've wanted to offer these the first option for you to include as well. Make sure that there is no language in there related to paying lesser of government rates. As Ileana mentioned, you know, the government rates are the government rates that the plans are required to pay. So what we've done is we've clarified for plans in case it was ever unclear that they have to strike from any provider agreement that language, and they have to remove that logic from their systems. And we had them attest to adhering to that requirement, which they all have done. So there shouldn't be issues related to that, but just be aware. The other thing is reviewing the contract just to make sure that whatever services you're authorized to provide, make sure that they're laid out in the contract, because ultimately at the end of the day, the contract is the vehicle for which you can get paid. So the services need to be in there, locations, whatever business you do needs to be in that contract. And as Tricia mentioned before, related to the all products clause, just make sure, you know, if you're contracting for the Medicaid line of business, that is indicated in the contract. So we are also asking providers to make sure that they're really paying attention to the claims activity. So we mentioned making sure that the lesser of language isn't in the contract, but also you know, looking and staying on top of claims that are being submitted, and if they're being denied, and, you know, working with the plans at the first step to resolve payment issues. And if you have you're not getting anywhere, then, you know, we have a link email that you can submit your issue and supported documentation to, so we can help you. We also have developed a methodology to be able to monitor payment of government rates just from a holistic perspective. So we're trying to stay on top and really make sure that we're monitoring all of this. So if providers don't have a contract in place with the plans, there's also a single case agreement that can be put in place so that your information is ultimately put in the system and payment can be made if you're not executing a full contract with the plan. So there's the next slide. We've provided on the OMH website, we've got really helpful resources on our billing site. It includes the billing manual that we distributed to the plans and providers that outline the billing requirements, but we also have a coding taxonomy that lays out the services and the units that will, you know, provide a guide for providers when they're submitting authorization requests. And so just make sure that you're following the guidelines that are listed on this website. If you have any questions, you can always contact us. And we're also monitoring our mailbox of complaints and issues that have come in, and we've received several emails from providers that have been confused about the authorization letter, thinking that it's a guarantee for claims payment, and it's not. So we're just spelling that out here for you to understand.
Okay. So just one last reminder, if you see an issue coming up, do not wait to call us. immediately call us. If there's any type of concern with contracting, any type of credentialing issue, please reach out to us. And if you have issues going forward with payment or getting authorization in the circumstances where you need authorization, or if there are circumstances where you are finding utilization management to be potentially excessive or concerning, reach out to us. OMH, OASIS, and DOH all have contact or access points that you can send information to us. So omh-manage-care@omh.ny.gov. For OASIS, we have the Practice, Innovation, and Care Management, or PICM mailbox, so PICM@oasis.ny.gov. And then for DOH, they have the Behavioral Health Transition to Managed Care.
Yeah, and we all
contact,
we work behind the scenes too, to help resolve the issues that come in. So, so it's a good process, and it's important that if there are issues that we hear from you, because then we can identify if there are trends happening throughout the state, if it will require guidelines to be issued. So it is important for us to understand what's happening out there.
And then, obviously, if you have any need for more technical assistance, MCTAC is a great resource. We've also got some additional resources provided to you here. The first link is to the Medicaid Managed Care Model Contract, which we showed you a copy of today. And then we also have policy and guidance documents for the plans and providers. It's contained on the OMH website. The DOH provider contract guidelines, and that's for the Article 44 corporations, so the managed care organizations, IPAs, and ACOs. And then there's also the DOH standard clauses for managed care providers, IPA, ACO contracts. And then the last link is to the OASIS residential redesign, which is a great resource document if you want to delve a little bit more into what the residential redesign looks like and how it works. And I believe that's it.
Thank you. I'd like to thank you guys for just spending the time reviewing these provider protections. I think it was very helpful. As I mentioned earlier, we will not be having a Q&A period, but providers are encouraged to submit any questions that they may have utilizing the chat feature, or the slides will be posted after the webinar. You can submit to the mailboxes that were listed within the presentation. So I just want to thank everyone for joining us, and on behalf of MCTAC, I hope you have a good rest of your day. Thank you.